Welcome back to the Bar Society podcast. We hope you enjoyed our first ever episode. Today, Melina and Megha will be interviewing Katherine Duncan, who is an alumna of the University of Aberdeen. Katherine is a barrister specialising in family law relating to children. She has a busy practice in public, private and international family law, while also being registered with the Bar Council to accept direct access instructions. In today's episode, Katherine will talk about her journey to the bar, while also providing an insight into her work as a barrister, sharing challenges she has faced and the rewards of being a barrister. She will also provide valuable advice to students. We hope you enjoy.
Hi Katherine, thank you so much for joining us today. How are you doing?
Good, thank you very much for having me.
Thank you for being here. So we're just going to start off. We have quite a few questions to get through today. Our first one is, can you tell us a little bit about yourself and your route to the bar? So when did you attend the University of Aberdeen? Which course did you take? And which Inn of Court did you join?
So I went to the University of Aberdeen in 2008 and I graduated in 2012. I actually started studying divinity and then I changed to history sort of about halfway through. Then I went straight and did the GDL at what is now called the University of Law. And I did that in York. And then I went to bar school at what was called Kaplan and is sort of now the ICA course. And then sort of just after I graduated, I joined Inner Temple and applied for a GDL scholarship before I started the course. Got a scholarship. And then after bar school, I had pupillage and then I got tenancy.
Is the GDL scholarship exactly the same sort of application process and interview as the bar course scholarship, or is it different?
It's pretty much the same. I think from sitting on the panels, I think on the bar course one, you might get a legal problem, whereas in the GDL, they don't expect you to know. So it's just really about you and your CV and how you present on your form in your application. But otherwise, it's similar. You know, do you know why you want to be a barrister? Do you know what areas of law you want to do? Do you have a plan? How are you suited to life at the career of the bar?
How soon did you gain a pupillage after you finished your bar course? Because I know now it's so competitive. There are so many more people doing the bar course than there are receiving pupillages. So was yours pretty easygoing, or?
I mean, it was very stressful. But I was very lucky that I applied for pupillage after I finished the GDL and got it that summer. So I knew I had it before I started bar school, and then I started straight after bar school. But I know that's not typical. There was certainly a handful of people in my year at bar school who were in a similar position. And then there was much more who got kind of the following year.
What made you sort of decide that you wanted to become a barrister instead of a solicitor?
So I initially thought I would be a solicitor. And I researched it into it a lot. And I looked at because when you're sort of deciding about a career in the law, the commercial solicitor route is really obvious. Mm-hmm. The firms do the most targeting, as the most information there is available. So I kind of assumed I would do that. But it was really when I started to look at what I liked and what I enjoyed. So I did debating all the way through school and at university. And being a barrister and doing advocacy was what I wanted to do. And so the bar would enable me to do that more than being a solicitor. And then when I looked into it more, I liked the idea of being involved kind of in the litigation, the end bit in court, rather than necessarily seeing a case the whole way through. For some people, they like being able to see a case the whole way through. As a barrister, I think you're involved in a very intense way, but in a much shorter period of time, and you tend to dip in and out of the case, even though you're kind of keeping an eye on it, whereas a solicitor handles it the whole way through and deals much more with the client and hold the client a lot more. But I guess it depends on the area of law as well. So I do family law and I started out in crime. So you're much more, the solicitor has them the whole way through and then you just come into court. Whereas if you're doing sort of commercial civil, you might be involved a lot more in terms of an advisory role, or rather than necessarily waiting until the end of court. So the divisions between solicitor and barrister aren't the same for all practice areas. I think it's actually more helpful to have an idea of what sort of area of law you might want to go into, because that will inform how your life at the bar looks like. So I'm in court every day. If I'm not in court, I'm not earning money. And that's the same for those who practice in crime and sort of personal injury at the junior end. Whereas I have friends who are in like commercial sets who maybe go to court once a year, and whereas they very much write advices on the litigation on quantum, and they're, you know, in chambers researching the law a lot more as opposed to being in court. So how you want your sort of daily life and practice to look like is also quite a big consideration when you're looking at solicitor versus barrister. And also solicitor versus barrister, most, like 85% of barristers are self-employed, so that's another thing to be looking in the mix when you're looking at solicitor versus barrister.
So you said you specialise in family law, children's law and public law. So what made you want to specialise and practice in these particular areas?
So I actually started out in crime because I wanted to be in court every day and I wanted to do the Crown Court jury thing, and I really enjoyed it. But I was doing a lot of work that involved domestic abuse, so I started to kind of see a lot of the issues we see in the family court in the criminal context, and I got quite frustrated with how the criminal court deals with domestic abuse. And I was doing a lot of work in the youth court, and again that really overlaps with the child protection work I do, the public law work that I do, because quite often those kids are in care or they've had quite disruptive family situations and have had social services involvement. So I got to see some of the issues from a different perspective. So I started doing both at the same time, and find that didn't work for me. And so then I moved over to family law. And the thing I quite like about family law is it's, generally speaking, very much forward looking. So you're trying to improve something, you're trying to improve a child situation, a family situation. And yes, you have to look back and determine what has happened to inform risk management looking forward, but ultimately you're trying to build something, whereas crime is reactive. So you're trying to determine what has happened in the past and then apportion blame. Same way with things like I guess like personal injury or professional negligence. You're trying to attribute liability, whereas in other areas of law you're trying to create something. And so yeah, I mean, I really enjoy family law. It's also quite, in the areas of work that I do, can be quite collaborative, although there's different sides. So in public there's local authority, there's parents, then there's the children. Ultimately you're all trying to work for this right outcome for the child, even if what you think is the right outcome will differ on what your client's instructions are, but you're ultimately trying to move the case along and work together as best you can until you get to like a final hearing or a trial where you're then against each other.
Yeah, I see. So in family law, you must deal with cases which are very sensitive in nature. So how do you deal with cases that are very emotionally charged and sensitive?
That is a work in progress, like all people. I think the thing I've really learned is to look after my physical health. So to exercise regularly, sleep well, eat well, because then that protects your emotional health and mental health as best you can. Taking breaks from it, talking to other people about it. Some cases will affect you more. They just absolutely will. There'll be some that break your heart and some that you can't forget. And there'll be things you can't see, that you've seen that you can't unsee. But the bar does offer a lot of support around that. There's a lot of work being done on vicarious trauma. So when you see constant bad images day after day, this sort of drip drip effect, and there's a lot of work being done around that. But yeah, I mean, sometimes you do quite well at not getting too attached, and sometimes you don't, and you just have to look after yourselves on the days when you haven't quite got the balance right.
Yeah, I think it's only human nature if you do find yourself more attached. So you represent both local authorities and you represent family members such as parents and guardians. What would you say are some of the challenges you face when representing local authorities, and how do they compare to the challenges you face when representing family members?
So when you're representing a local authority, you're representing an organisation. So your client skills are different. Who instructs you at court is not necessarily the person who has the final say, so they need to get instructions from their manager, and the position needs to be signed off at senior levels. So that's quite a different relationship and way of representing someone, because it's an organisation. For parents, it's different again because they're an individual and it's their child, and quite often they have their own vulnerabilities, which is why they're in care proceedings in the first place. So that can be learning difficulties, substance misuse. So that's quite difficult and brings its own challenges. And then guardians, so what we mean by that is the children have their own representative in the proceedings. So they're a party to the proceedings and they have a court appointed social worker who acts for them, and then they instruct a solicitor. So again, it's a professional you're acting for as opposed to a parent. So that's different. They're often they're generally experienced and have seen a number of care cases, and so are able to take a much more wider look at the impact on the child. But sometimes they represent teenagers who are deemed to be competent, so they can instruct their own solicitor. And sometimes the guardian and the child agree as to what should happen to the child. And sometimes they disagree. And if they've been assessed as competent to instruct their own solicitor, then they will do that. And so the guardian might have their own barrister and the child's solicitor might have their own barrister. And so then you're taking instructions through the solicitor, but from a teenager. And again, that brings its own set of challenges and rewards.
Katherine, you mentioned that in family law you're in court a lot. What would you say are your sort of top tips for advocacy before the court?
I think preparation. I think as long as you know your papers inside out and you know the law you at least anticipate is going to be an issue, then anything else you can handle. But you need to really know your case, your papers, and your instructions, because there will be stuff that comes up, or you'll be challenged on something, and there will be unexpected things to deal with. But I think preparation is the key.
And how long do you usually have to prepare for a case?
It really depends. So don't get as many night before instructions as I used to when I first started. And certainly when I was doing crime, they would be like the night before, sometimes in the morning, or sometimes just literally when you're on your feet. Nowadays, I usually get sort of 2-3 days notice. I'll probably get the papers 2 or 3 days in advance. I'll know the updating position kind of the day before, maybe a bit before. And that's if it's like a new case. But if it's a case you have ongoing, then you're more likely to know the position much sooner, because you're instructed the whole way through. And also you then don't need to reread as much because you already know the case and have read it. So that's kind of like for your everyday hearings. For like trials, you usually have a bit more notice because the solicitors know the trials in the diary and you get the papers in good time for that. So, I mean, it just kind of depends. In the work I do, there's often emergency hearings where the local authority wants to remove a child that day. And sometimes you don't get papers until the night before the morning or until you turn up to court. And you just have to read as best you can and find out what your client's saying. And if necessary, ask for more time or ask for an adjournment in order that they can be properly represented. But the court has to balance at that point that the local authority says this child is at such risk that they have to be removed today. So it can be quite difficult, like managing all of that at once.
So just going back to cases before the court, it's obviously not possible to, win every case, and losing cases just comes with the territory. But how do you cope with losing cases at times, especially if they were very important in nature?
Again, it's a work in progress. It is quite frustrating when you lose and you think you shouldn't have. Not to the point that you can appeal, but just that, that it was finally balanced and the judge went one way and not the other. I think in my area of law, I don't think we feel like we lose so much because ultimately, in the family court, we really don't try and promote this idea that there are winners and losers. Like mum doesn't win as opposed to dad wins as to who gets the child to live with them and time spent. And ultimately, you're trying to work for the right outcome for the child. And quite often, particularly in private law cases where it's like mum versus dad, depending on the issues, like if there's no like risk factors like domestic abuse or substance misuse, and it's just two parents who love their child and don't know what to do, quite often nobody wins everything they want to, and there needs to be some kind of compromise and middle ground. So you're kind of more like negotiating to get a good outcome as opposed to everything your client wants. So that doesn't really feel like a loss and doesn't really feel like a win. But yeah, there are some cases that are a kick in the teeth and you do feel are unfair. But you brush yourself off and you don't really have time to think about it. You have to prepare tomorrow's case.
Right. And you mentioned before 85% of barristers are self-employed. What are the advantages of disadvantages of being self-employed and being responsible for your own workload and earnings?
So whether it's an advantage or a disadvantage really depends on your individual perspective. But for me, self-employed means that there's quite a bit of flexibility. So I say to my clerks when I'm available to work and when I'm not available to work. But on the flip side of that, there's no HR department checking that I'm not working too hard or doing too many cases or overloading. Like, I have to manage that. And that's a skill that takes time to learn. What money you earn is yours. And for some people, that's quite nice, like a sort of eat what you kill philosophy. But then there's no safety net. So there's no parental leave, there's no pension, there's no sick leave. So you have to sort that out yourself and make savings yourself. You are responsible for your own cases. So there's no one checking that you haven't made a mistake or someone signing off on the work that you've done once you're past pupillage. You need to know what you're doing because nobody checks if you're right or if you're wrong. I guess it can be quite isolating at times, depending on the kind of work that you do. And now that we're all a bit more remote, whereas I think if you work in a firm, you have a team and you're working as a team, and some people quite like that. I, for one, have never been particularly good at teamwork, so I wouldn't be good at that. But for a lot of people, employed really works for them and their circumstances. They get paid on a regular basis, whereas I only get paid when my clerks bill it and the solicitors put it on the system and remember to pay me. So sometimes I won't get paid for a case that I haven't done in months. We're likely to have age debt at the self-employed bar where that money is yours and you can see it on the system, but you don't have it in your bank account. Whereas if you're employed, you have your salary coming into your bank account every month. You can budget better. You're not worrying about how you're going to pay rent. So it just really depends what works for you. So most employed barristers probably work in a big organisation. So the big ones are like the Crown Prosecution Service, Serious Fraud Office, regulators, or big banks, or work in-house at solicitors' firms, or in-house at local authority legal teams. So it just really depends what works for you. I know there's some pupillages available at the employed bar. From what I understand, it's quite easy-ish, as easy as it is to move chambers, to move across between the employed and self-employed. If you've done a pupillage in one and find it doesn't really work for you. But yeah, it just depends on your preferences. One's not better than the other.
So, Katherine, do you have any advice for mini pupillage and pupillage applications?
I think really research, first of all, what being a barrister is, what area of law you want to go in, and why you're applying to that set. A lot of people in the application I've seen just don't do that, and it's like the real basics that you can prepare for. There's so much in applications you can't prepare for, but those are questions you're always going to be asked. So you can prepare and redraft and redraft and redraft really good, solid answers to those so that you always have them. With mini pupillages, quite often, I'm not sure what the current practice is, but when I was applying, it was quite often just a CV and a covering letter. So why you're interested, what you like about the chambers, and your availability. Pupillage applications are much, much, much bigger beasts, and do take a very long time. But yeah, prepare those stock answers and then spend a lot of time thinking about your skills, how you can transfer them, how you can bring different aspects of yourself to each question with different examples, and then try and have them done in time. So when I did it, because I think I had 2 mini pupillages lined up over Easter, so I wanted to have my form as up to date as possible, which meant that I couldn't send the applications until the Monday, and I finished the mini on the Friday. And the system, despite starting sending them on the Saturday, the system crashed. It took me 21 hours just to get them to send. Like, they were already drafted, they just took 21 hours to send, and I lost my mind a bit. So try and have them done in advance. I don't know what the system's like now, but I know for years there would always be crashes because people would leave it to the last minute. So try and get them in before that.
And how much would you say having mini pupillages helped you when it came to the real pupillage? is it, I know the bar now suggests around 4 to 5 mini pupilages before you secure a real pupillage, but what do you think in your opinion?
I think 4 to 5 is good if you can get a benefit from them. But if you know after 3 what you want to do, there's no point doing 4 and 5. So my understanding is that, like, in pupillage forms, there's only so many points you're going to get for mini pupillage. So you need to have at least one, but I don't think you get points for having 5 as opposed to 2. What they're more interested in is what you can learn from them. So I did 5. I know that I did 1 that was family, so I could explain that I'd looked into that, and at the time it wasn't for me. I did 1 that was in Leeds, so that I could say, well, I've thought about being on circuit, but London's for me, and here's the mini pupilages I've done in London. I did 1 in like a pure criminal set, and then 1 in like a mixed set. So again, I saw the difference between that and whether that would work for me or whether it didn't. So the variety I did worked for me because I learned lots of different things from them that better informed my choices. But if you know that all you want to do is be like an intellectual property barrister, then you only need to do 1 or 2. Frankly, I'm not even sure there's that many chambers that do intellectual property law, for example. But if, for example, you absolutely know that you want to do clinical negligence and you've got the work experience from it and you can back that up, I'm not sure there's a huge amount of benefit in doing 4 and 5 if you've done 1 or 2. They just want to know that you've been in a barrister's chambers and that you know what you're getting yourself into. For me, there's also an argument that I think it's a lot to ask people to do 4 or 5. Like, it's 4 or 5 weeks of unpaid work, traveling. If you're from Aberdeen, staying at the other end of the country, like, it's really expensive. So I think there's an element of which people just need to be a bit realistic about that.
So what is one thing you wish you knew before embarking on a career at the bar?
I've really thought about this question and I really don't know. I mean, I really had researched everything about the bar. I had read every guide going from years and years. I had met lots of barristers. I had gone to events. Like, I did really know what I was getting myself into. So I don't think there's anything I wish I'd known. But what I think would have been helpful is, like, when I was starting at the bar, is I really thought I was signing up to a life of just being a workaholic. And to be honest, I was very happy with that as a choice I made when I was like 22. Now I'm 32. That wouldn't work for me. And what I didn't know, and what I do know now, is that you can have a work-life balance at the bar. Yes, it takes effort, and sometimes you get it right, and sometimes you don't. And sometimes it's a disaster, and sometimes it's great. But I didn't know that going into a career. As I say, I thought I was signing up to a life of being a workaholic, and while I was very happy to do that when I graduated, now I'm a bit older, I'm pleased that that's not the life I was signing up for.
If you could give one piece of advice to students at Aberdeen University wanting to pursue a career at the bar, what would you say?
So I think Aberdeen students have a difficulty in that they're just so far away from like chambers. And it's hard. But if you can try and physically be in London or the place where you want to work, even if it's just to get a mini, and then when you're there, try and squeeze in as many bar things as you can, because there is a benefit to talking to barristers, to being involved at the inn, or even if you can't physically get there, go to as many remote things as possible. So I know they offer way more remote things than certainly when I first started. I mean, I just don't think they'd ever heard of remote. So try and go to as many things as possible. I know it's physically far. I know it's really difficult. Like, I just slept on a friend's floor for a summer in order to get the experience that I needed to get. And yes, it was difficult, but being able to sort of absorb the culture, because then you get to understand, like, what are the issues at the bar, what's the current thinking, how it really works, and you pick up a lot that you can't pick up by looking on the internet. But at the same time, don't be persuaded by the fact that you are a million miles away or are Scottish. And because when I went to interviews, people just thought I was weird that I was coming from Aberdeen. And it was fine. Like it made me memorable. People, wanted to know why I was here, and that was like an easy question. Like I could answer that, no problem. So people remember you, and it's fine. So don't worry. Don't think that you're cut off from everyone. People find it interesting, and like there are people who come from overseas who need to get pupillage, and you don't have anywhere near the difficulties that they do, because you don't need any of the visa requirements and money and all of that. And yeah, they do find if you're Scottish quite interesting. Like when my husband and I go to events at the inn and he wears a kilt, like they're just absolutely fascinated, and they all want to come and talk to him and ask if it's like a family tartan, as though he was just wearing a random tartan. Like it's okay that that's part of your like selling point, but do try and like go to England, because that is where you're going to practice, and they'll also want to know like why you're going to be there, because like for me, all my family is still in the same postcode in Aberdeen, like all of them. So that do you know that you're committing to a life that is far away from that, and how is that going to work? So try and go if you can. I know it's difficult, but I think that would be my advice to Aberdeen students in particular.
Thank you so much. Thank you.
Thank you for listening. Please follow us on Instagram at barsocabdn and on Facebook at Bar Society Aberdeen to stay up to date on upcoming episodes of our podcast.